Welcome to the Leagles Educare podcast series, an initiative to bring across to you latest case law developments in the nation and also have a detailed discussion on the various provisions of law. I'm Martha Phillip and that's my co-host Ajit. Today, we shall be discussing Section 27 of the Indian Evidence Act through various legal developments. The Shraddha Walkar case, a murder case that took the city of Delhi by storm. Shraddha, a young and ambitious girl, was strangled by her live-in partner Aftab Poonawala, who later cut her body into parts and disposed her off into various parts of Delhi. The situation came into light when Shraddha's father lodged a missing complaint. On interrogation, Aftab told the police that he had murdered Shraddha. He also told the police that he had butchered her into pieces and disposed her body parts into the Mehroli jungle, in a drain, behind a certain mandir in Chhatarpur enclave. This whole confession made to the police was so precise. It's an open and shut case for the prosecution, isn't it?
No, it is not.
And why do you say so?
Because the confession made to a police officer is not admissible against the person who made the confession. Because Section 25 of Indian Evidence Act says that a confession made to a police officer, like in this case, Aftab made the confession to the police officer. So it will be inadmissible. It cannot be used as an evidence against Aftab at the stage of trial.
But whatever he said to the police is relevant, right?
Yeah, the statement is relevant, but the confession is not admissible.
And there's a difference between admissibility and relevancy?
Yes.
All right.
So whenever a criminal wrong takes place, there may be certain main facts which need to be determined in order to decide the rights and liabilities of the parties, right? So these main facts are surrounded by certain other facts. There is a logical connection between other facts and the main facts. Let's understand this through an example. Suppose there was a quarrel between A and B on Diwali night over some firecracker issue. On that night, A did not do anything, but he said, I will see you tomorrow. Next day, around 12 p.m., A kills B by stabbing him. So in this case, the main fact that is fact in issue, that is whether A murdered B. So in order to prove this fact in issue, we need to prove certain other facts as well, these surrounding facts as well, right? So that quarrel that took place on Diwali night between A and B, that is relevant, that can constitute motive, that is relevant under Section 8, right? There will be a knife by which A stabbed B. There will be fingerprints on the knife. There will be blood on the spot. There will be blood-stained clothes. So all these facts are surrounding facts. And there is a connection between main fact and surrounding facts. This is called the relevancy. These facts are called relevant fact, and these relevant facts are defined under Section 6 to 55 of Indian Evidence Act.
Okay.
That is called legal relevancy.
Right.
Yeah. So whenever we want to prove any fact in the court of law, first of all, we need to prove that this fact is a relevant fact under Section 6 to 55, any of the provisions. Then once that relevant fact is duly proved, then it will become admissible.
Okay.
Yes. So confession is relevant, but it is inadmissible because Section 25 prohibits the admissibility of the confession made to a police officer.
So what I've understood so far is Section 6 to 55 of the Indian Evidence Act talks about relevant facts.
Yes.
Now when these relevant facts are duly proved in the court of law, only then they become admissible.
Yes.
So all relevant facts may not be admissible.
Yeah, we need to prove through evidence, through documentary evidence or oral evidence.
Right.
Yes.
So there's another question which comes up to my mind. Now let's suppose there's an accused and he makes a statement in the lockup to an inmate. He confesses his crime or just makes a statement that I have killed B and I've hidden the knife at a certain place. I've hidden the body parts at a certain place. He's made this statement, to a passing statement to the inmate inside the lockup, and the police officer hears this whole discourse. Now, is this a piece of confession and will this be admissible?
No, it is also not admissible because the accused is in the police custody. So section 26 of Indian Evidence Act prohibits the admissibility of a confession which is made to any other person while he is in the police custody. So this police custody can be of two types: direct police custody or constructive police custody. Constructive police custody, let's understand this through an example. Suppose a police officer takes an accused from one place to another place by a train, and during the journey the police officer needed to go to the washroom, so he hands over the accused to some other person, and to that person accused confesses his guilt. So this confession will be hit by section 26 because accused is in the constructive police custody. Let's take another example. Suppose a police officer takes the accused for his medical examination to the hospital, and the police officer remains outside the doctor's room, and the accused confesses his guilt to the doctor. So still this confession will also be hit by section 26 because the accused is in the constructive police custody.
So custody can clearly be of two types.
Yes.
It is physical as well as constructive.
Direct or constructive.
Direct or constructive.
Yes.
Now let's get into the main discussion, which is section 27. What exactly is section 27?
Section 27 says that the fact discovered in consequence of the information given by a person who is an accused of an offense while he is in the police custody. Practically what happens? And a person is arrested. Now he is in the police custody. He gives a statement. This statement can be a confessional statement or non-confessional statement. In that statement, he discloses the whereabouts of a particular object or a thing. This particular object can be a weapon which was used in committing the crime. It can be blood-stained clothes. It can be a mobile phone. So this particular object or thing has some connection with the crime which he has committed. After that, the police officer will record his statement. This statement is called disclosure statement, right? Because in this statement, he discloses the whereabouts of that particular object. Thereafter, the police officer will take the accused to the place which he has disclosed in his statement. And there, upon his pinpointing, that particular object will be recovered or discovered in the presence of two witnesses. These witnesses are called punch witnesses. After that, the police officer will prepare a discovery memo in which he will mention the items which were recovered, and this discovery memo will also be signed by the witnesses.
Right.
Yes.
Now, what are the active ingredients of section 27?
Okay, let's dissect section 27. The Supreme Court has in numerous cases has elaborately explained the various ingredients, the main ingredients of section 27. Number one is fact discovered. Fact discovered means the place from where that particular object is discovered, and the accused had exclusive knowledge regarding the place of concealment. In case of Himachal Pradesh administration versus Om Prakash, in that case the Supreme Court said the expression fact discovered does not mean the dagger. Rather, the dagger which was hidden by the accused under a stone, which was revealed to the police by the accused, which was not only known to the accused. In case of Pandurang Kalu Patil versus State of Maharashtra, the Supreme Court said the expression fact discovered does not mean the gun recovered. Rather, the gun which was hidden by the accused under a heap of wood, only known to the accused, which was revealed by the accused in his disclosure statement. Right? What I am trying to say, the fact discovered does not mean that particular object. It is about the place from where that particular object is recovered, and the accused had exclusive knowledge regarding that place of concealment. Like in Shraddha Walkar case, अगर आफ्ताब ने वो बॉडी पार्ट्स ऐसी जगह पे फेंके हैं जहां पे कोई भी जा सकता है, किसी को भी एक्सेस हो सकता है, तो वो और उसके बाद डिस्कवरी होती है, तो वो डिस्कवरी एविडेंस नहीं माना जाएगा. बट अगर उसने इन बॉडी पार्ट्स को थ्रैश बैग में डाल के कहीं छुपाया है और बाद में उसने अपने डिस्क्लोजर स्टेटमेंट में उन बॉडी पार्ट्स के बारे में बताया और उनकी फिर डिस्कवरी होती है, तभी वो सेक्शन 27 में फॉल करेगा।
राइट।
तभी वो डिस्कवरी एविडेंस माना जाएगा, तभी वो रेलिवेंट होगा अंडर सेक्शन 27।
So fact discovered is not the object. Fact discovered is actually the location where it was concealed.
From where that particular object was recovered. Yes.
And also exclusive knowledge of the accused. He only bears that knowledge.
Yes.
Right. What is the next ingredient?
Next ingredient is the information. This information can be confessional or non-confessional. And this should be about the fact discovered. Fact means the place from where that particular object was recovered and the accused had exclusive knowledge regarding that place. Now, third ingredient is the person should be an accused of an offense. The Supreme Court in case of State of Uttar Pradesh versus Dioman Upadhyay, 1960, it is a 5 judges bench judgment. The Supreme Court said the expression person should be an accused of an offense is merely a descriptive. It means a person against whom the evidences are being presented in a criminal proceedings. It is not necessary that the such person should be an accused when he gave the statement. It is not necessary that there shall be formal accusation against him for the applicability of section 27.
Okay.
See, what happens? जब भी कोई इन्वेस्टिगेशन होता है तो बहुत सारे क्राइम में क्या होता है कि ऐसा सर्टेन नहीं होता कि ये पर्सन अक्यूज्ड होगा, राइट? तो उस दौरान तो सभी सस्पिशन में होते हैं,
राइट?
कोई भी अक्यूज्ड हो सकता है, वो ऐसा कोई स्टेटमेंट दे सकता है जिससे कोई डिस्कवरी होती हो, बाद में पता चलता है कि वही अक्यूज्ड है, तो हम उसको डिस्कवरी स्टेटमेंट मानेंगे ना, डिस्कवरी एविडेंस मानेंगे ना,
राइट?
वो बाद में उसको अक्यूज्ड बनाया गया ना। सो इवन इफ सच अ पर्सन इज विद इन द कैन ऑफ सर्वेलेंस, he is an accused.
Okay.
For the purpose of section 27. हमें इसको थोड़ा broadly interpret करना पड़ेगा. Next ingredient is the person should be in the police custody when he gave the statement.
Okay.
Right. In case of State of Uttar Pradesh versus Dioman Upadhyay, again, the Supreme Court said, even if a person after committing a brutal murder comes to a police officer and offers to furnish an information against himself, then he is said to submit himself to the police custody without any formal accusation against him. Right? यहाँ पे उसने स्टेटमेंट पहले दे दिया, राइट? तो फॉर्मल एक्यूजेशन नहीं था उसके, तो उसको ये मान लिया जाएगा वो पुलिस कस्टडी में उसने खुद को सबमिट कर लिया, ही इज इन द constructive police custody.
That means any kind of submission even before a formal complaint was lodged against him, still he will be called an accused.
He will be in the police custody.
And he will be an accused.
Yes.
Right.
So in case of State of Andhra Pradesh versus Gangula Satyamurthy and Dharamdiyo Yadav versus State of Uttar Pradesh, the Supreme Court said, even if a person is within the ken of surveillance of the police, where his movements are restrained or restricted by the police, then for all the practical purposes he is in the police custody.
Okay.
It is called custodial surveillance.
So any kind of restraint, any kind of restriction, or even when he is under surveillance, that is also termed as custody.
Yes.
All right. Before we were recording, we were talking about this article that you had read. It was very interesting, where you told me that the Supreme Court has made some kind of a error, right?
Yes.
And Justice
V. Ramkumar. Yes, right.
Justice V. Ramkumar has criticized the judgment of the Supreme Court. Please throw some light over that issue.
So before discussing that article, first we need to discuss the last ingredient. That is, how much information is relevant.
Okay.
So the information that distinctly relates to the fact discovered. Only that much of information will be relevant under section 27. एक स्टेटमेंट दिया, कन्फेशन किया उसने, अक्यूज्ड ने, उसमें एक पार्ट है जिससे डिस्कवरी होती है, वही पार्ट रेलिवेंट होगा सेक्शन 27 में, बाकी रेलिवेंट नहीं होगा, बाकी एडमिसिबल नहीं होगा, बिकॉज बाकी जो कन्फेशन होगा वो 25 या 26 से हिट हो जाएगा.
अच्छा, जैसे उसने बोला कि मैंने मर्डर किया और मैंने कैसे मर्डर किया और मैंने कब मर्डर किया, वो सब रेलिवेंट नहीं है. रेलेवेंट ये है कि मैंने इस वेपन से किया और वेपन मैंने यहाँ पे जाके छुपाया है और इसकी नॉलेज से
आई विल टेक यू देयर.
आई विल टेक यू देयर.
ओके. मैंने यहाँ पे छुपाया है, आई विल टेक यू देयर, और फिर पुलिस उसको लेके जाती है.
हाँ.
और वहां से उसका जो वेपन है वो रिकवर किया जाता है. यही जो स्टेटमेंट का जो पार्ट होगा ना, वही रेलिवेंट होगा सेक्शन 27 में.
ओके, बाकी कुछ रेलिवेंट नहीं होगा.
या नाउ कम टू दैट आर्टिकल that is written by Justice V. Ramkumar. In that article, Justice V. Ramkumar has critically analyzed Section 27 and also criticized the Supreme Court's latest judgment in case of Rajesh Yadav versus State of Madhya Pradesh. Brief facts of this case are: a 15-year-old boy named Ajit Pal had disappeared while he was going to see Holika Dahan. He was allegedly kidnapped by 3 of his neighbors. When these kidnappers have realized that Ajit Pal's parents have informed the police about their ransom, so they killed the boy. It is assumed that the main accused, Rajesh Yadav, cut the boy's throat while other accused held him. After that, the police apprehended all these accused. They recorded the statement, recorded their confession, and at the instance of accused number 1's confession was recorded. After that, discovery was made at his instance. In that discovery, the body of the boy was recovered in the presence of witness from a well. The knife which was used, blood-stained knife, that was also recovered at his instance. And a liquor bottle was also recovered. At the instance of accused number 2, the mobile phone which was used for making ransom call was recovered, and his blood-stained clothes were recovered. At the instance of accused number 3, his blood-stained clothes were recovered. The Court of Session found all of these 3 accused guilty and convicted them and sentenced accused number 1 and 2 to death sentence, and accused number 3 was given life imprisonment. And in appeal, the High Court has confirmed their sentences. Now they have approached the Supreme Court. The Supreme Court has actually interfered with many factual findings given by the Court of Session or the High Court as well. But we are going to confine to Section 27 only. Regarding Section 27, the Supreme Court said accused were apprehended. They were taken to the police station on 29th March. 28th March. Okay. Accused number A's arrest was shown on 29th March, 6:30 p.m. Accused number 2's arrest was shown on 31st March, 5:40 p.m. And accused number 3's arrest was shown on 5th of April, 3:40 p.m. Now, on 29th March, investigating officer examines accused number 1. He records his confession and discoveries were made. Thereafter, he was made formally an accused. So, in effect, he was not an accused when he made the statement when the discovery was made. Same goes with the accused number 2. Similarly, his statement is recorded first, discoveries were made first, then he was named as an accused later. So in effect, these accused were not accused. For there was no formal. They were not made accused formally. Right. So Section 27 will not apply. So the Supreme Court has acquitted all of these accused. Now, Justice V. Ramkumar, in his article, and I also agree with him, he says that when these accused were apprehended by the police, they were taken to the police station, right? There, they recorded their confession. After that, discoveries were made. So, no sensible person, no reasonable person can say that they were not in the police custody.
Absolutely.
Right? We have discussed state of Uttar Pradesh versus Dioman Upadhyay. We have discussed state of Andhra Pradesh versus Satyamurtha Ganguly. We have discussed the Dharamdiyo Yadav versus state of Uttar Pradesh. And there are many cases. So they were in the police custody. Right? So there were lapses on the part of the police. So prosecution had to pay that price.
Right.
Yeah, Supreme Court should have interpreted in that manner that they were in the police custody and they could have got convicted.
Yeah, because in the earlier judgments we've read and you've also detailed, you've told us in detail that for a person accused to be in custody, no formal written complaint needs to be made, right?
Yeah, the Supreme Court should have followed state of Uttar Pradesh versus Dioman Upadhyay. It is a landmark judgment and it is a 5 judges bench judgment.
Yes. Okay, coming on to non-confessional statements.
Okay.
What is the status of such statements, and what does law talk about it?
If it is a non-confessional statement, then the matter will not fall under section 24 or 25 or 26 of Indian Evidence Act. The matter will fall under section 162 CRPC. Section 162 subsection 1 CRPC says that a statement given to a police officer in the course of investigation cannot be used as an evidence. It has no evidentiary value except contradiction. But subsection 2 of section 162 creates a saving clause for dying declaration and discovery statement, that is section 27. So section 27 is saved under section 2 of 162. So section 27 in case of non-confessional statement is an exception to section 162 subsection 1, and in confessional statement section 27 is an exception to 24, 25 and 26. Yes,
right. So for non-confessional, section 27 is an exception to 162
subsection 1. Yeah,
right. Okay, last question which comes to my mind now. So if an accused has been subjugated to some kind of threat, coercion, उसको मारा पीटा गया है, और या तो उसको कोई promise कर दिया गया है, or he has been induced and he has been promised that your sentence will go down, or for that matter he has been beaten up in the lockup, and then he gives a confession. What about such cases? What is the admissibility of such confessions?
So as per section 24 of Indian Evidence Act, if a confession made to a person in authority and that confession was taken because some coercion was used, compulsion was used, or threat is used, or promise was made, inducement used, so that confession will be irrelevant, right? But section 27 will still apply because it is an exception. It is a proviso to section 24, 25, 26. But when threat is used, when some force is used, then article 20 clause 3 will come into play because of the constitution, because article 20 clause 3 says that a person cannot be, an accused cannot be compelled to be a witness against himself.
Yeah.
So you cannot compel a person to give testimony or give evidence against himself.
Right.
Confession, what is confession? Confession is giving evidence, giving statement against himself, right?
Right.
So in case of State of Bombay versus Katika Lowgad, the Supreme Court said if the threat is used while recording the confession, while taking the confession, then it will be hit by article 20 clause 3, and section 27 will also be hit by article 20 clause 3. So you cannot use that discovery evidence as well. But if the promise or inducement is used, then article 20 clause 3 will not come into play.
20 clause 3 only comes into play in threat and coercion.
Threat and coercion, or some kind of force is used.
Force is used.
Yes.
जैसे उनको डराना धमकाना, उनको मारना,
custody
में लेके तब यूज होता है. 20 clause 3 के अंदर आएगा.
Yes.
And it also bars 27 का discovery statement.
Yes.
Right? I think it's been quite a productive session, and not only have we known about section 27, but we've also gone into the intricacies of section 27 relating to custody, whether it be physical or constructive custody. We've talked about the various ingredients of section 27. Also, we've talked about non-confessional statements, and we've talked about article 20 clause 3. And very enlightening was that whole article that you've talked about of Justice
V. Ramkumar,
where he's talking about a error in the part of the Supreme Court. This session has been quite productive, and I think we'll come back to you with more podcasts, with more informative knowledge. And the whole initiative behind this session or this series is to get across to you latest case law developments. If you do like our content, please like, share and subscribe. And you can also connect with us through various social media handles on Instagram, on Twitter, and also on our website. Thank you so much.
Thank you.